Remember when phones were just for, making calls? Those were simpler times. Now, our phones are practically external brains. They hold our photos, our conversations, our deepest fears, mostly about running out of data. So, when we hand them over to law enforcement, what are we actually giving up? That's a question courts are grappling with, especially in the cases of Riley v. California and United States v. Sultanov. These cases aren't just about phones, they're about the fundamental right to privacy in an age where our lives are increasingly lived online. And folks, let me tell you, that right is looking shakier than a giraffe on roller skates. Imagine this, you're pulled over for a busted taillight, a minor infraction. Next thing you know, the cops are scrolling through your text messages, your emails, even your grandma's secret meatball recipe, which frankly should be protected under the Geneva Conventions. That's the kind of overreach these court cases are trying to prevent. The digital age has ushered in a whole new world of challenges and the law is playing catch-up. But hey, at least we have cat videos to distract us while our privacy slowly erodes, right? Stay tuned as we delve into these landmark cases and try to make sense of this brave new world of digital privacy. Back in 2014, the Supreme Court heard a case that would send shockwaves through the legal system and make every cop's head spin faster than a disco ball at Studio 54. That case was Riley v. California. David Riley, our protagonist in this legal thriller, was pulled over for expired registration tags. Seems simple enough, right? Well, the cops decided to search his phone and wouldn't you know it, they found evidence linking him to a shooting. Riley argued that the phone search violated his Fourth Amendment rights against unreasonable searches and seizures.
The search of my phone was a blatant violation of my Fourth Amendment rights. My phone is not just a container, it's my life.
Now, the Supreme Court, in their infinite wisdom, or at least slightly more wisdom than usual, sided with Riley. They recognized that cell phones are not just ordinary containers like, say, a glove box or a fanny pack. Though, honestly, let's bring those back. No, cell phones are basically portable filing cabinets containing vast amounts of personal data. The court ruled that searching a cell phone without a warrant is unconstitutional, except in very specific circumstances, like if there's an immediate threat to safety. Basically, they said that our digital lives deserve the same protection as our physical belongings. This decision was a huge win for privacy advocates, proving that even in the digital age, the Constitution is more than just a dusty old parchment. It's a living document that adapts to the times, even if it takes a Supreme Court case and a whole lot of legal wrangling to remind everyone. Fast forward to 2024 and we find ourselves at the border, a place where tensions are high, tempers are short, and the lines are longer than a CVS receipt. This is where the saga of United States versus Sultanov unfolds. Our man, Vadim Sultanov, a dual US-Russian citizen, was stopped by Customs and Border Protection (CBP) at a Washington airport on his way back into the country. During questioning, CBP officers decided to search his phone.
I was shocked. I knew the border was different, but I didn't expect my phone to be searched without any real reason.
Now, this is where things get interesting. Unlike Riley, which involved a search during a routine traffic stop, Sultanov's case took place at the border. And as we all know, the border is a magical place where the usual rules don't always apply. The court ruled that while border searches are generally permissible, they still require some level of suspicion. A simple, suspicionless search, like the one conducted on Sultanov's phone, violated the Fourth Amendment. The court drew a line in the sand, or should I say, passport control line, stating that the government's interest in border security cannot come at the expense of our fundamental rights. The Sultanov case might seem like a small victory in the grand scheme of things, but it sets an important precedent. It reminds us that even at the border, our digital privacy is not something to be trifled with. Now you might be thinking, John, these cases seem pretty different. What's the common thread? Well, my friend, the answer is as simple as it is important: probable cause, legal expert. Both Riley and Sultanov emphasize that law enforcement needs a good reason to go digging through our digital lives. In Riley, the cops needed a warrant to search the phone, and in Sultanov, CBP needed reasonable suspicion to justify the border search. Think of it like this: your phone is like your home, your digital sanctuary. The government can't just barge in without a good reason, just like they can't break down your door without a warrant. Attorney Stephanie Scarborough reminds us that This principle of probable cause is crucial because it prevents arbitrary and intrusive searches, even of travelers at the border. It ensures that law enforcement can't just go on a fishing expedition through our personal data, hoping to find something, anything to use against us. In a world where technology is constantly evolving, it's more important than ever to hold on to the fundamental principles that protect our freedoms. Probable cause is one of those principles, a cornerstone of our justice system that ensures fairness and prevents abuse of power. Section 5. The shifting sands of border control (CBP) policies under scrutiny. CBP officer, the Sultanov ruling sent a ripple effect through the world of customs and border protection. Suddenly, the rules of the game had changed. CBP can no longer assume that just because someone is at the border, they can search their phone without any justification. Attorney Stephanie Scarborough. This has sparked a debate about the balance between security and privacy at our borders. On the one hand, we need to protect ourselves from threats, both foreign and domestic. On the other hand, we don't want to live in a police state where everyone is treated like a potential criminal. CBP has been under pressure to update its policies in light of recent court rulings, and rightfully so. Attorney Scarborough reminds us that CBP needs to find a way to protect our borders without trampling on the Constitution. It's a tough job, but hey, nobody said protecting a nation from rogue squirrels and oversized bottles of shampoo was easy. Section 6. Finding the balance, protecting privacy without handcuffing law enforcement. So, where do we go from here? How do we balance the need for security with the right to privacy in the digital age? Well, folks, if I had all the answers, I wouldn't be yelling at you about it on television. I'd be sipping mojitos on a beach somewhere, probably still yelling, but at least I'd have a tan. But seriously, finding the right balance is crucial. We need clear laws and policies that protect our privacy without hindering law enforcement's ability to do its job. We need to ensure that searches are conducted only when there's a legitimate reason and with proper oversight. This isn't just about protecting ourselves from the government, though that's always a bonus. It's about setting a precedent for the future. Bottom line is, even at the US border, CBP needs both probable cause and a warrant to search your phone. As technology advances and our lives become increasingly intertwined with the digital world, we need to make sure that our fundamental rights don't get left behind. We need to find a way to live in a world where we can enjoy the conveniences of technology without sacrificing the freedoms that make America, well, America. And if we can do that, then maybe, just maybe, we can all go back to worrying about the truly important things in life, like whether pineapple belongs on pizza, it doesn't, or if socks can be considered formal wear. They absolutely can't.